Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about new legislation in Ontario that regulates election finances, including third-party advertising, spending limits, and a per-vote subsidy. Many organizations have criticized these changes to the law as undemocratic, unethical, and in some cases even unconstitutional. For example, the new law doubles the annual donation limit. It increases the per-vote taxpayer subsidy to political parties, something Ford promised he'd get rid of before he was elected premier. And the new law also doubles the pre-election advertising registration period for third-party advertisers from 6 months to 12 months, meaning that third parties need to register with the government to talk about political and policy issues. Today, I'm going to be joined by three legal experts who work in this area: Toronto lawyers Asher Honickman and Ryan O'Connor, and by Duff Conacher, the co-founder of Democracy Watch. Thank you so much for joining me today. Now, let's start with the easy stuff, the per-vote subsidy. Before he was elected premier, Mr. Ford called the per-vote subsidy political welfare. It results in millions of taxpayer dollars going to political parties. But he didn't get rid of it, and he's actually increasing it. Mr. O'Connor, your reaction?
Well, thanks again, Christine, for having me. I come from maybe an older school. An individual has the romantic notion that politicians ought to keep their promises to the extent possible. And I agree with Mr. Ford's former characterization that this is subsidizing political parties with taxpayer dollars is political welfare. If a political party's message lacks resonance such that no one wants to donate to it and it requires a subsidy, then perhaps that political party should either change its messaging or potentially put itself out of its misery. This is akin to forcing someone to donate to an advocacy group or a charity whose aims and objectives they oppose, but are still forced to do so regardless. This is not something that, in my view, is necessary in our political system. And I'm hopeful that after the last election, given the hiccups with political financing with COVID, that the next government will see it fit to eliminate the subsidy.
Now, Mr. Conacher, what's your view on the per-vote subsidy and on Mr. Ford changing his tune on this policy?
Well, it is the most democratic part of the political finance system because it is based on the number of votes that you receive. But it was set at an arbitrary amount, and it gives the parties way too much money, likely. Although for all aspects of the political finance system, there needs to be a study done of what it actually costs to run a party, run a riding association, and also run a campaign and reach voters. And that should be the basis of every limit and any subsidy that exists. When you couple it with doubling the donation limit, and one thing a lot of people didn't notice is that the per-vote subsidy is actually going to be handed out as a lump sum at the beginning of next year. They're going to get essentially almost all of the money they would get through 2022 as one lump sum at the beginning of the year, which is going to build a big war chest for all the parties. And when you combine that with it being an arbitrary sum and also a broken promise, Democracy Watch has long called for an honesty in politics law to penalize broken promises, it adds up to just another bad move.
Mr. Honickman, the per-vote subsidy is relatively new to Ontario, and it's not a policy everywhere in this country. You know, notably, the federal government had it and repealed it under Prime Minister Harper. In your view, is a per-vote subsidy necessary to protect democracy?
I mean, I'd say it's the opposite. It's a classic example of a law that when you're outside government, you promise you'll repeal it, then you get in and you say, well, actually, now we're going to benefit from it. The irony here is that not only had Ford promised to repeal it, as I recall it, it had been repealed. It was scheduled to be repealed January 1st, 2022, and it's now effectively been brought back with a higher subsidy than before. So that's a bit odd, but it's not surprising. It's the classic example. It's not that different from Justin Trudeau campaigning that he's going to get rid of first past the post, and then he comes in with a majority government and he says, well, you know what, first past the post is actually pretty good. So we do see this sort of thing all the time. The per vote subsidy, I don't see it as something that enhances democracy in any way. What it does enhance is incumbency. It makes it more likely that incumbents will will win elections because they're essentially being, they're receiving a benefit for having won, which the only benefit for having won should be that you're in government.
We're going to continue this conversation after this commercial break. Welcome back to Canadian Justice, where we're talking about political financing laws and some of the new changes to those laws in Ontario. One of the big changes is to the pre-election third-party advertising limits. Mr. O'Connor, can you explain? Now, I'll add that you actually represent a third-party advertiser called Ontario Proud. Can you explain how the pre-election registration requirement works and works for clients like yours?
Sure. So as soon as a third party elects to spend $500 or more on regulated advertising, so that's advertising that promotes or opposes a candidate, political party, party leader, or is advocacy that speaks to an issue that's associated with a political party, a candidate, or a leader, that they have to register with Elections Ontario, filing documentation, confirming that they wish to be accepted as a third party, and Elections Ontario reviews the documentation and makes that determination. Any organization that wants to talk about a political issue during a regulated period is required to register, even if it's only spending $500 or something a little bit more than that. And then there are spending limits that apply as well in the pre-election period, which starts in this case May 4th of this year. Can spend indexed to inflation $600,000 before the writs are issued for the election, and an additional $100,000 during the election period itself.
Now, Mr. Conacher, you've criticized this change to the third-party regulation period that has extended it from 6 months to a year now. Can you explain what, in your view, makes that law problematic?
Yes, I think actually likely unconstitutional in terms of unreasonable limit on freedom of expression. And the reasons are, first of all, that it relates to issue advertising, not just advertising that opposes or supports a candidate or a party.
Now, let me stop you there, Mr. Conacher. What is issue advertising? Can you give me what the definition of what an issue ad versus a political ad might be?
Well, at the federal level, the political ad is called partisan ads, and the feds have only limited partisan advertising in the pre-election period and required the registration for it. This bill limits it for and requires registration for issue advertising, which is essentially advertising about any policy program or proposal or bill that the government might put forward.
So that might be, like things like climate
debate.
Change or balanced budgets.
Any issue that would be associated with the position of any political party or candidate, which is essentially every issue, because the platforms of parties are quite broad. When you require parties or third parties, interest groups that are going to spend only $500 to not only register, but then file detailed reports, that is too much regulation. Requiring them to register is fine. That's needed to be tracking whether there is collusion between third parties to know who is advertising, and then be able to examine who they are and where they might be getting their funding. But to require them to then also file substantive reports regularly as they spend more and more, there should be an exemption for that. If you're spending less than $10,000, you should really only be required to register. That's the way it is at the federal level. And to cover this all for 12 months before the election campaign begins is also going too far and arbitrarily setting a limit of $600,000. The old limit was $600,000 over 6 months. Now it's $600,000 over 12 months. The government's offered no rationale for why they have extended the period for a year but kept the same spending limit. And so it all adds up to an arbitrary action that unreasonably limits freedom of expression. And again, the key thing that needs to be done is a study of how much does it actually cost to reach each voter. And that should be the basis of any spending limits, including spending limits for the parties and any subsidy. And that should be the basis for the analysis of the whole political finance system. And nobody wants to undertake that analysis because it's actually probably, you could set quite low limits because it doesn't cost very much with email and social media to reach voters anymore. And so it's just all an arbitrary act and another bad move by the Ford government.
Mr. Honickman, we've got about 30 seconds. At the high level, what constitutional concerns do you have with the third-party advertising limits?
Well, as my colleagues have suggested, it's a freedom of expression issue. We are chilling expression by one, making it less likely that people are even going to want to sign up as third parties because of how onerous it is, and then, and I think we're going to get into this a bit in the next segment, limiting really what people can talk about and when they can talk about it. So we'll get into that in the next segment, I think.
Yeah, absolutely. Ryan, Asher, Duff, we're going to come back after this commercial break and talk about that. Welcome back to Canadian Justice, where we're talking about election financing laws. And Mr. Conacher, I want to follow up with you about something we talked about in the last segment, which is what constitutes political advertising versus issue advertising. And there's this extremely broad definition of issue advertising. That means it's an advertisement that takes a position on an issue with which a political party or candidate is associated. I imagine for advocacy groups across the country who engage in comments on public policy issues, this includes just about everything they do. Can you comment on that?
Yes, I think it will. And as a result, I think that the coalition of unions, which had already challenged the old limits and just hadn't proceeded with their case in the past couple of years, will apply for an injunction against these new limits and likely win it. And that's what happened when the federal government went too far in the 90s to try and limit third-party advertising. And the injunction was won a couple of times, and the limits were suspended until the courts ruled on the limits. So essentially ended up having no limits for those couple of elections that happened until the federal government proposed a reasonable limit that went up to the Supreme Court and was upheld. So I think that's what we're going to see happen in this case. And we won't actually have any limits for the next Ontario election because of the injunction that will be in place.
It's going to have a big impact. Now, Mr. O'Connor, I want to ask about the impact on third-party advertising groups themselves. What would the consequence be on these groups of a law like this? Is it going to silence them?
Well, it will. It will silence those groups that can't afford a lawyer to help them navigate the rules. It will silence those groups that can't afford to pay an auditor to review their spending, while privileging political parties, incumbent politicians, unions, and corporations. Unions and corporations have an exemption an ongoing exemption under the Election Finances Act, despite these amendments, to continue to communicate with their membership as they see fit on the issues that are relevant to them and are not subject to spending limits. But a small group, maybe Torontonians for Trees, who cares about conservation, cares about preserving green space, they have to monitor whether or not the Green Party or the New Democrats, the Liberals or the Tories want to talk about trees. Because if they do, their regular advocacy work is now issue-based advertising, and they have to register if they spend $500 on that issue. But not only that, every single time they spend or commit to spending $1,000, they have to file a new report with Elections Ontario. Small advocacy groups are simply going to just raise their hands in the air and say, this is too much bureaucracy. I'm not going to participate in the public discourse. And our political discourse in Ontario is going to be more impoverished for it.
Yeah, I actually can think of my own neighborhood. I've seen things like that about lawn signs that are distributed by a community-based group related to either trees or about sidewalks, which are a big issue in my neighborhood. And they could be caught under this law if the parties are taking on an issue with that. Now, Mr. Honickman, what's your view on the constitutionality of this definition of issue advertising? Do you see a problem there?
I do, Christine. The reason is that, go back to the Harper decision of 2004, which I think Duff was referencing. If you look at that decision, the court goes into a real detailed analysis of why the law was okay there. And like many charter cases, it comes down to this idea of minimal impairment. And what the court also talks about in that case is balancing freedom of expression against the need to have a fair election, essentially. And it's really hard to see how laws that are this onerous are necessary to preserve a fair election. And in fact, you could argue the opposite, that by making the laws this onerous, you impair the fairness of the election by restricting the amount of speech and thus restricting the information that ordinary citizens can obtain.
Mr. Conacher, you had mentioned earlier that there is an existing legal challenge brought by some union groups, and I imagine that's possibly why the Premier was interested in enacting this legislation, if it has the potential to silence his union critics. But are there other challenges, and what do you think the likelihood of success of that challenge might be?
Well, as I mentioned, I think they will first move for an injunction and likely win it, because starting May 4th, these limits will be in place and the registration system will be in place. And it's quite onerous. And again, as we've been discussing, covers any advertisement you do, because there's one party or another registered in Ontario that will be addressing that issue, and that makes it an issue ad that's covered by the law. So I think they'll win that injunction, and I don't think the courts will finally rule on the limits before the June 2022 fixed date election, if we don't have an election earlier than that.
It'll certainly be really
win the injunction, and we likely won't have any limits for the whole next election campaign period, which is maybe something that Mr. Ford wants. He may have set this all up.
Welcome back to Canadian Justice, where we're talking about Ontario's election finances laws. Now, I want to turn to some positive aspects of this law, things you guys might actually like with some of these changes. Asher, I know that you have represented an MPP, an independent MPP, who challenged this legislation, and there have been changes to the provisions of this law governing independent MPPs and their ability to fundraise. Can you explain what happened and what those changes mean?
Sure. So what the law in Ontario said before this new change came in was that you could only start raising money for an election once the election writ was dropped. Now, for members of parties, the way they get around that, in a very legal way they get around that, is by having their riding association raise money for them for their prospective candidacy all through the entire 4 years between elections, so that on day one of the election, their riding association transfers their campaign tens of thousands of dollars. The problem was independents couldn't do this, and it was because of this and because of some other inequalities that my client, MPP Randy Hillier, brought a constitutional challenge. And in response to that challenge, the Ontario government amended the election finances law to allow independent members, now for the first time ever in Ontario history, to form their own riding associations. So if you're an independent member like Randy Hillier or like Roman Baber, you can now make a riding association. We call them constituency associations in Ontario. You can now raise money between elections. That is going to not equal the playing field, but create at least some semblance of equality between independents and party members.
Yeah, seems like a good move for democracy as well. Mr. Conacher, your views on changes to the law that relate to independent candidates? What do you have to say?
It was a good move, and the same problem exists in most jurisdictions across Canada and at the federal level, and the changes haven't been made there. The one thing is, I don't think there is enough reporting required of these independent candidates of how they're spending this money that they're raising. And so, and there really isn't by riding associations and parties overall. Parties and riding associations can raise money now, and so will independent candidates be able to raise money. And they can use that money really for a lot of things that they don't have to tell even party members about, because all they have to do is file a rather vague financial return each year. There needs to be more disclosure by all of them so that members know what they're using this money for, including whether they're going to be using it for their own personal purposes, which would be pretty easy for an individual candidate to do, given they don't have to report the details to anybody.
Interesting observation.
That's the one thing that needs to be cleaned up about this.
Mr. O'Connor, we have about a minute. Anything you like in the new changes to the law?
Well, I'm happy that the government has recognized that the anti-collusion provisions, so those are the provisions of the old law, now the new law, that prevent third parties from colluding with one another to circumvent or overcome the spending limits. We saw in the last election that so-called progressive third parties, particularly unions, and there were a few examples of this, they were donating to smaller third parties, so that the total amount they were actually spending on third party advocacy exceeded the limit. And I'm thinking of one of those unions in particular, and I don't know that Elections Ontario did anything about it. So those anti-collusion provisions have been tightened to very clearly indicate that a third party cannot donate to another third party. So it's leveled the playing field in that respect, which last time, with all due respect, was being taken advantage of by so-called progressive.
That's all the time we have, Ryan. Thank you all so much for joining me.
Thank you.
We've heard today about new legislation in Ontario that has expanded taxpayer support for political parties while limiting the ability of advocacy organizations to advertise about the issues they work on. We've heard about how some of these measures could enhance democracy and about how others could undermine it. It's extremely tempting for politicians to take taxpayer money to help them get reelected and to enact laws that could muzzle their critics through spending limits and regulatory hoops. It doesn't matter their political stripe. Premier Ford has now embraced and even enhanced the same policies he criticized his predecessor, Kathleen Wynne, for enacting. Portions of this new law may in fact be unconstitutional, but until it's struck down, third parties need to abide by it. What will this mean for incumbent power and for democracy itself? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.